last for You Friday session for 2020. So, because we're going into the holidays, and I just wanted to thank everybody for being here today. And especially thank you to Stella Edens Pederson, who is from um, Gravis Law in Richland, Washington, in the Parkway. And she is going to be here today to talk to us about estate and will planning. So I will turn it over to her. And if there are any questions, I don't know how you want to do this. Either people can ask questions during your presentation, or would you rather they table those or send questions through message and I can kind of watch those? It's your preference.
I'm happy to take questions while we go through it.
Okay.
It's a little hard to watch for questions in the chat because I got to get up close and look. But if they wanted to message something to you and they didn't want to speak, maybe you could just throw that out at me. I'll try to take it slow. Yeah.
Okay, so if you guys would have questions, just let Stella know, or if you want to put them through Messenger, I will go ahead and check those and let her know. So with that said, I will mute myself and I'll turn it over to you, Stella, and thank you very, very much.
Oh, well, thanks for having me, and thank you for all dialing in on your Friday off. I know you've had some more fun topics in the past, like winemaking or travel tips, and estate planning isn't the most exciting topic, but usually when I give this presentation to groups, people find it really informative and just gives you something to think about. I'm going to go ahead and try and share my screen so that you can see the presentation. Okay, there we go. And then what happens is I can't see what you see anymore, which makes me sad. Can you see that presentation? Did it do it?
Yes, I see your
Looks
first
good to
slide.
me.
Yes.
Okay, with Gravis Law and estate planning?
Yes.
Mm-hmm.
All right. Okay, so I see you guys and I don't see the presentation. So if I turn sideways, it's because it's here. Okay, so I'll tell you a little bit about myself. So you know I've got college-age kids now already since we've been chit-chatting. I've been an attorney for 25 years, and I've always practiced in estate planning and probate. In previous jobs, I also did a lot of corporate work and business succession planning and a lot of real estate. So I ended up working with a lot of big farmers in the area, so I got to do kind of the whole package. I joined Gravis just under 2 years ago, and my role here is just estate planning and probates, and I run the whole department across the Gravis footprint. Gravis is a younger firm. It's been around about 4 or 5 years, but it has offices in 5 states. We are in Washington, Idaho, Montana, Michigan, and Florida. We have our Richland office, and we are about to acquire a Kennewick office so we can better serve across the Tri-Cities. It's funny how some people they don't want to go that other direction, you know. So I'm really excited about that, and I've really liked Gravis. We do a lot of different work, but my passion has always been estate planning because I really think that it helps provide some structure for families. Like for business owners and farm families particularly, it provides a structure for families to own assets beyond one generation. But even if you don't own a business, just having an estate plan is, we're not moving. Why is it not moving? There, providing an estate plan, I really think it provides a plan for your family, right? And it's kind of a gift to your family because it gives them some structure. When the family leader is getting sick or failing, people get really nervous, and it's an emotional time anyway. So if you can put some parameters on that to give your family and your children some guidelines to how to get through this kind of traumatic process, I always feel like it's a gift. When I've seen too many families, and particularly in families that maybe you're not married, you know, but they have cohabitated and built a life together, when someone is going to pass away, you kind of leave everyone out on their own little island and they all start scrambling, and it's just a horrible experience to live through. So when we do estate planning, there are 3 basic documents that we talk about that kind of apply to everybody. And I'll go through these pretty slowly. They're different, and if you have questions, feel free to chime in. The first document that's kind of the most simple to discuss is the Healthcare Directive, and that's also known as a living will. And what that does is it tells your family and your physicians what kind of extraordinary care you want if you're in a terminal condition. So you can say, I do want artificial nutrition and hydration, or I don't. You know, our form at Gravis, and most of them, they're kind of a multiple choice. I do want this treatment under these conditions, or I don't want this treatment. If you're a woman, your healthcare directive is not going to be valid if you are pregnant. So that's something to know. It's also not a legally binding document. Your healthcare providers can choose not to follow it, but it's really important to have a statement of your wishes, because it helps, again, helps your family guide them in a time of crisis and give someone instructions at least about what your wishes were. You know, there was a big case not a few years ago, it's probably like 15 years ago by now, out of Florida, the Terry Schiavo case. I don't remember if you guys remember that. She had never written anything down, and she was married and she had parents, and she was in a terminal condition. And there was a lot of expensive court fighting about whether or not they should, you know, turn off her life support. You know, if she had had written instructions, it would have been more clear, and that family could have avoided making that trauma so much worse. Does anyone have any questions about that before I move on? No? Good. Okay. The next document that we recommend for everybody is a durable power of attorney. And what that does is it gives someone else authority to take care of your personal affairs while you are still alive. The term durable just means that it continues to be effective if you are not able to handle your affairs yourself. So if you become incapacitated, it's still effective. Most powers of attorney are drafted so they're not effective until you're incapacitated. So it seems kind of redundant, but some people do want assistance while they still have the mental capacity to take care of themselves. You know, I see older people who are just like, you know, I've been doing this for 75, 80 years. It's time for my kids to help. So you can give that authority while you're still alive. But this is also like one of the most abused and fought about documents, because it gives someone authority to manage your affairs. And what you see frequently is that someone will use that authority to start siphoning money out of your estate, you know, and changing your estate plan so that it benefits that person and not maybe, you know, their other family members. You know, I see that a lot, particularly not so much amongst like your own children, if you name one of your children, but if you don't have kids and you're naming like nieces or nephews or friends or something. So you want to be careful who you give that authority to, because you want it to be someone who is trustworthy and will watch out for your best interests. Your power of attorney has a fiduciary obligation to do what is in your best interest, but you know, not everybody does that. So you got to be careful who you give that authority to. I usually recommend to my clients that they don't give that authority to someone unless they absolutely, you know, or until they're incapacitated. The alternative is to hire a professional trustee or fiduciary to act as your power of attorney, because then there are some legal guidelines and some corporate policies that are also going to, you know, make sure that they do what's in your best interest. For people who don't have family, I refer them to, you know, there are several businesses around that provide trustee and fiduciary services, and I'd really rather see people end up with a professional, you know, power of attorney than, you know, someone who's going to take advantage of them. Any questions? Okay, thanks. Sometimes I get a lot of questions, but maybe it's people I know better. I don't know. So then the final document, the power of attorney is only effective while you're still alive. This is a really important thing that a lot of people don't know. So the minute you pass away, the power of attorney is no longer effective. So then when you pass away, the last will and testament takes over. So this document says, you know, who gets your stuff, who's responsible for getting it there. If you have minor children, you know, who's going to take care of your children, you know, how is your money going to be used for that? You know, the important things in your will are that you have capacity to sign it and you understand what you're signing. And the rule about capacity is you have to understand, and this is a weird legal term, but your natural bounty, right? You have to know who your family is and who would be the natural people to inherit your stuff. You have to know what your assets are. You got to know what your stuff is. And you have to understand the document that you're signing and what it's going to do. So like I've been a professional expert in cases where like grandma had lost her capacity and really couldn't sign a new will, and we needed to make changes to her estate plan, or her attorneys did. So they asked me to come in and interview her. And so I had to ask her, you live in this lovely, assisted living facility, how do you pay for this? And she didn't know. And then I asked her about her children, and she could come up with her children, but it took a while. But then she didn't know, she didn't think she had any grandchildren, and she had like 11, so she didn't know who her family was. And so I was able to give an opinion to the court that, she didn't have capacity to sign a new will. And so there were other ways they had to, work on changing her plan. So those are kind of the three basics that we kind of start with. Everyone needs to have a complete estate plan, but there are lots of circumstances where it's maybe more complicated, or there are other documents that make the process more simple. So some other common tools that we use, the first one we use most often is a community property agreement. And people always ask, I thought Washington was a community property estate or state. Don't we have that anyway? And we do. So what that means is anything you acquire while you're married is community property, and it belongs 50% to each spouse. But each spouse still retains the right to give their 50% to whoever they want. They don't have to give it to their spouse. So if they wrote a will, and I've had clients who did this before, my wife has plenty, so I'm giving my 50% to the kids now, instead of waiting till the wife passes. So a community property agreement says that when I pass away, everything I have automatically goes to my surviving spouse. What that does for you is you don't have to go through the probate process when the first spouse passes away. So it's just a little bit, it's a lot easier actually for the surviving spouse when the first spouse passes away. We do these almost automatically, like if you have a couple where it's your first marriage and the kids are your kids together, and you don't have like a complicated taxable estate or anything. That's the ideal family for this. But I will get, and let me know if I'm talking too fast. Sorry. Okay, good, thank you. But I will get like second marriages where really everything they built together during the second marriage, even though they may have had kids from prior marriages. So everything's already community property, and they don't want things, they just want it to go to the surviving spouse. So, but it's a conversation to have with my clients about whether this is appropriate or not. But the community property agreement is most common. And sometimes couples will choose, particularly like young couples maybe that don't have a lot of money to pay for a full estate plan. They're just married and everything they have is together. They may not have kids. They're going to try and get something simple and cheap. And so they'll just do the community property agreement. They don't really have a complete plan because they don't have the healthcare directive and the power of attorney. But if something happened, at least they're taken care of. The next most common thing is pre- and post-nuptial agreements. And so what that is, and people get really uptight about prenuptial agreements, like, aren't we planning to get divorced? But there is a whole range of, I call them we'll talk about them as prenuptial agreements. You can do it after the marriage too. It's just an agreement documenting who brought what to the marriage. Anything you own before you get married is your separate property. Anything you inherit or receive as a gift is your separate property. And what that means is that you 100% control that. And any growth or appreciation or increase in value, that is yours. And your spouse does not necessarily have a claim to that. If you mix that up with your marital, your community assets, you can lose that character as separate property. We recommend anytime a couple is getting married later in their life and they both have their own assets that they're bringing to it, particularly if there are significant family assets, whether it's a family-owned business, maybe a family cabin, up at Lake Coeur d'Alene or in the mountains, or, something that your family wants to keep and doesn't want to get, tangled up with your spouse if you get divorced later. I recommend doing a mutual agreement or a separate property agreement just to document who owns what, so that if someone passes identified for probate purposes as this their property and this was the community property, and those get state law is going to govern how your assets get distributed. If you don't have a will that says how you want it to go, the state is going to give your community property 100% to your spouse. Your spouse is going to get 50% of your separate property, and your children, your own children, are going to get 50% of your separate property. Usually, that is what the state would do, is not necessarily what an individual would plan for their own family, which is why I like to have things written down and documented. To do a prenuptial agreement, one of the keys in Washington state is that you have to disclose all your assets and all your debts before you enter into the agreement. So each side has their own list that spells out everything you have, and each side has to have their own attorney that advises them on the effects of this agreement. And the reason for that is because usually when we're getting into these situations, one of the new spouses has significantly more assets than the other, and they kind of have the control. And so we want to make sure that everybody understands the rights that they're giving up, particularly, like I said, if there's family businesses, or if the agreement is going further than just identifying, separate property and community property, if it is planning for what happens if we get divorced, or what happens if I die and you don't get to inherit what you would get under Washington state laws, we want to make sure that everybody understands. And so both attorneys on each side have to sign that agreement as a participant, confirming that they have advised them and that both sides knew what they were doing when they signed it. Because the state courts will not enforce a prenuptial agreement or any sort of a separate property agreement if there hasn't been independent legal advice on both sides. So what happens a lot of times is couples don't want to pay two attorneys, and I have to explain to them, you have to, or it's not really worth the paper it's written on. But I do have a number of attorneys that I've worked with around the community, and so I will usually refer that second spouse to one of those attorneys, so they already know what our separate property agreement is going to look like. And we just have worked together enough. We know they're going to get good advice. It's not going to jack up the system. Every once in a while, I'll get clients who we are negotiating a prenuptial agreement because they're coming into a separate marriage, and one spouse will use their prior divorce attorney for this process, and that person has that attorney has a completely different perspective, right? There'll be they're fighting for the next divorce kind of all over again, and making sure that and it's no, we're just trying to list out separate property. We are not, so that can really slow down the process because that attorney has a different perspective. So that I've had some prenuptial agreements that never got signed because the former divorce attorney wouldn't allow them to. And of course they get married anyway. And I guess that attorney has saved themselves for that next divorce. The other common, I guess I should stop. Any questions? Okay, you guys are a quiet group. Okay, a minor trust. Now, a minor trust, if you have minor children, we're automatically going to put that into your will. And that's going to say if my child is under a certain age, we're going to name guardians for them. And then we are going to set up a trust so that any funds that child would inherit are managed for them until they reach a reasonable age. And, they're used to just set up what that money can be used for until that child is an adult. One of the stories I always tell on this is my best friend from high school. She inherited some money from her grandma when she turned, I think, 18. And so in college, she had a lot of great parties and a really nice car and a really fancy stereo. But by the time we were out of college, she had nothing left, right? You don't give an 18-year-old $20,000 or $25,000 or God forbid more money than that, right? So we want to hold it. And parents, when you're writing your will, you get to set up the terms of that. So, lots of families will say the money can be used not only to raise them, it can be used for college, it can be used for a car, it can be used to fund a mission, it can be used for secondary education, and maybe for a down payment on that. We can set up all kinds of parameters around how that is used, then you also have to name who's going to be the person that manages those funds for your child. The most common language we put in our minor trust is that it's held in trust to be used for secondary education until they're like 25. You figure by 25, people are kind of finished, But I always, defer to parents. Your kids. Some people have super responsible kids who really can handle it at 20, and other people have super irresponsible kids who are not ready to handle it at 40. So we have those conversations about, tell me about your family. And then a living trust, you hear a lot about these their ads in the newspaper, maybe commercials on TV, and this is a totally different thing. So what a living trust does is it takes your assets and puts it in a trust while you're still alive. You're the trustee to manage it for yourself while you're here, and then when you pass away, you've named a successor trustee to step in and continue managing the trust in accordance with whatever your wishes were. The advantage of that is that it avoids probate. So that's really, a living trust doesn't do anything your will can't do, but it is more important in some states than others. Washington State, again, about 15, 20 years ago, they did a lot of changes. They really simplified our probate process. So it's pretty streamlined, and I need a whole separate presentation just about probates. But when we start a probate, we file some paperwork with the court issues what are called letters testamentary, and then that authority is what allows your executor to gather your assets, pay your bills, and then after about 6 months, if everything's been handled, then the probate closes. It's pretty straightforward, and the court isn't normally involved a whole bunch. But in other states, that is a completely different process. So like in California, their probate fees to the court are a percentage of your assets. So people jump through heck and high water down there to avoid the probate system. Other states, the process takes longer. The court is involved every step of the way. It's a more expensive process. Every state has their own rules, and they're very, very different. I was tangentially involved in a probate out of Ohio one time because our original executor had lived there. And anyway, that took 5 years because the court had to approve everything, every distribution, paying every bill. Paying every attorney bill. It was ridiculous. So Washington State is pretty straightforward, but we do still do some living trusts if people who don't want to manage their own assets, maybe in their retirement, maybe because they plan to travel, or they just don't want to do it themselves, and those people might choose a professional fiduciary to do that for them. If people, right before the year 2000, I had a lot of older people who were getting married right before the new millennium, right? And so we did a lot of living trusts right before they did that, just to hold their separate property separate. Instead of doing a prenuptial agreement, they wanted to just be trustee of their own trust and keep, build a fence around their separate property that they were bringing to these marriages. So what was interesting about that was none of those marriages made it past 2 years. So getting married because of an artificial date doesn't work.
I think Anna Maria had a question about something.
Sure.
Okay, so it's funny, this is really timely because we were looking into doing a trust. And granted, we have a financial planner that's in California, so maybe that's why they're, telling us to do that. However, we're in a situation where, we've got a few properties, we have some assets. My final parent has recently passed. They had an estate that will be distributed. We still have, there's still with that estate a property in California, which my sisters and I might keep. So, with all those circumstances, would it be advisable to have a trust?
I would want to know what all the assets are, but certainly for the next story I tell about living trust is I do that. I have had clients who bought and sold the same house in Palm Springs. And so we always put that house in a real simple living trust, just so at least that asset avoids a California probate.
Right.
But I wouldn't necessarily recommend having a trust that you have to put everything in. My concern about living trust is it's administratively kind of a huge pain in the patootie, right? Because once you you have to put all your assets in there, because if you don't, then you still have to do the probate anyway. And for the rest of your life, you have to own your assets as, Stella Pederson, trustee of the Pederson Family Trust. And, have to have separate bank accounts, and just there's like an extra step in the middle of everything you do. If you're trying to buy a house, you have to make sure it goes in the trust. So you have to provide the mortgage company and the title company with copies of your trust documents. You have to make sure everything is titled just right. I just administratively for just your life, it's more of a hassle than doing the probate is in Washington. But yes, for the property in California, I think that that's a great idea. And the thing I like about that, and here's another option we do for that too, where it would be you and your sisters, is instead of a trust, you could set up a family limited liability company.
Yeah, that's what we were talking about. So I wouldn't have to do a trust.
I like the family limited liability company because that company is going to have an operating agreement that is going to outline how you continue to own that property jointly, and how you contribute to expenses for that property, and if you want it to continue down to your children, how that works as it transfers down to generation. It's going to set up like voting blocks for each family. I just really love the LLC for that kind of multi-child, multi-generational family asset. And I set up a lot of those for those family cabins, that people want to stay in their family, because it helps also, if that's the intent for the property, to identify that as your children's separate property when they later get married and have children, particularly if you want it to pass down to children and grandchildren.
Okay, so bottom line, I guess for everyone here, it doesn't matter how much you have or own in Washington, really a living trust doesn't make sense.
For Washington assets, right. And the living trusts that you hear about a lot, and I'm just going to throw them under the bus here. Ryle Moulton advertises these. He holds free lunches and he invites seniors in and he scares them about the probate process. And he says, our living trusts solve every problem. But a good solid estate plan solves all those problems too, and doesn't cost as much and is not as complicated to set up. He puts in those trusts everything everyone could possibly need, and most of the time doesn't spend the time with his clients so they understand what happens. So when a married couple sets up a joint living trust, for example, it's the Bob and Susan Smith family trust. Most of the time, when the first spouse passes away, that trust is supposed to divide into Bob's share of the trust, which is now irrevocable because he passed away, and Susan's share of the trust, who is still revocable because it's her stuff and she's still alive. Most families don't do that. So then what happens is when Susan Smith dies, her kids come to me or whoever it is with this trust document and say, okay, here's what's supposed to happen. And it's like, well, but the first stuff was supposed to happen, sometimes it's 15 years ago when Dad died and you didn't do it. And so we have to sort through like what was supposed to happen, what should have gotten divided. We've got to file, if it's a taxable estate, we've got to file an estate tax return for a guy that died, 15, it just is a mess. And people don't understand those complicated documents. For like an isolated property in another state like that, those trusts I always keep super, super simple. It's just to own this asset to avoid probate. And here's what happens to it when we go. And that is not as complex.
Okay, that's good. So when you say assets, you're talking like physical assets, real estate, whatever, as opposed to cash type investment assets, stocks, bonds, and all that. That's not state limited or.
Right. The real property in another state will force you to have to do a probate in that estate.
Okay.
The nice thing about the LLC is it takes that real property asset and it makes it an investment asset. So you're not going to have to do that ancillary probate in another state to transfer that.
Okay, I won't take any more of everyone's time, but I might have to talk.
That was great. It brought up a whole other level of discussion we hadn't got to yet. Thank you.
Yeah, no problem. Thank you.
So the living trust is used pretty commonly, but I think there should be a purpose for it. Obviously, it's not my favorite thing. It's more expensive to set up because the document is a custom document, and then you have to put all the assets into the trust. If you're doing a good job, there are attorneys in town who do living trusts, or used to be, and they always made sure they were funded. And so clients would come to me, do I need to undo this? And I'm like, no, you, particularly when it's already funded, but maybe we can simplify it so that you understand.
Okay.
So I've mentioned a couple of times the term taxable estates, and Anna Marie, you may be interested in this. It sounds like, your parents have done well and you guys have done well. So Washington State has a state estate tax that kicks in at $2.193 million. And what that means is when you pass away, up to that, we're just going to call it $2.2 million, can pass to anybody without owing any estate tax. Any amount that passes beyond that is going to pay some tax to the state of Washington. In the state of Washington, the estate tax starts at 9% of the value of the assets over that 2.2, and 19%. So, this Washington estate tax isn't horrible, but it's there and it can be easily avoided. Oregon's estate tax limit is only 1 million, which I just think is way too low. Idaho has no estate tax, so I put kind of our three, most recent or most local states there. Colorado has no estate tax. Montana has no estate tax. I've actually had some clients who moved just to avoid it. So, okay, if you don't feel you need to be here, that's fine. But the most common way, the federal exemption is 11 million, over 11 million each. Same thing that can pass to anybody without paying any estate tax. There is an unlimited marital deduction at both the state and federal level. So when the first spouse passes away, you can leave everything to your spouse and there won't be any estate tax paid at that time. But looking ahead, though, we're trying to make sure that when the surviving spouse passes away, that there isn't still more money and they're going to have to pay estate tax on that money when after they pass away. There's an easy way to double that. It's the marital trust. So what we do with the marital trust is when the first spouse passes away, they have whatever their exemption is. And so we set up a trust for the surviving spouse that uses the full amount of that first spouse's exemption so that it reduces the surviving spouse's exemption or assets, the surviving spouse's assets when they pass away. So you can easily get, in Washington State, you can get almost 4.5 million down to your kids without paying estate taxes. And certainly at the federal level, you can get 22 million. And if you got more than that, that is a complicated plan that's going to involve a lot of accountants. But it's a fun project. I've done it. So it's pretty easy to double the amount by building some potential trusts into your will. And so what we do, and a lot of attorneys in the area do, is we set up in the will what is called a disclaimer trust. So it says, when I pass away, I specifically instruct my spouse to talk to our attorney and our CPA and decide if they need to set up this trust. And then the surviving spouse can disclaim, which is saying, I don't want to inherit this money directly to myself, so that it goes into a trust. And that marital trust is available for the surviving spouse while they're still alive. They have to get all of the income off of that every year, and they have access to the principal of that amount too. But then any appreciation that happens in that trust, if there's investments that are growing, it passes down to the next generation free of any further estate tax. And so it's an easy option, like I said, to double your exemptions. If you are more than the $4.5 million for Washington and you're like 10 million or 15 million, we've got some of these. There's some weird language that allows you to take the amount that's above the Washington limit and claim it as a federal exemption and then flip it. It's complicated, but it's kind of fun too. But at the federal level, they have what's called portability. They brought this into effect about 10 years ago. And what that allows you to do is say, when your first spouse passes away, I'm not going to set up that trust, but I'm going to file an estate tax return and I'm going to claim their exemption amount. So they're 11.2, that's theirs. And so it kind of gets set aside. And so when the surviving spouse passes away, they get to use both exemptions. So for a married couple that has 15 million and you want to avoid federal estate tax, you can take that, just carry it. It's portable, right? It goes with you. And that can be carried on to the next spouse. If your surviving spouse gets married later, it gets a little complicated. But that does require you to file a federal estate tax return when the first spouse dies to make sure that the IRS knows you're claiming that. And that's kind of an expensive process. That's like $10,000 or $15,000. So, you know, you've avoided maybe the probate and everything else, but you still have to pay, you know, just a pretty good chunk of money to just claim that. But if you're in that tax level, you can afford it. But they do not have portability at the state level. That's only a federal option. I have used that one time, and it was back when the limits were like half of this amount. I had a client who owned a business and his wife had passed away, and her will had set up a trust that said, you know, the marital trust, you know, my husband has access to this, but then when he passes away, it goes to my kids, which would have been fine, but he had a child that was causing some trouble. Like, mom had died, she wanted money now, even though dad was still alive. And so we didn't want to set up that trust because that gave that troublesome child some rights as a contingent beneficiary to come cause trouble in the trust. So we did the federal estate tax return and claimed portability so that all the assets came to him and he didn't have to worry about his daughter, you know, trying to badger him further until he passed away. And this is one of my karma's kind of a bitch stories. She ended up passing away before he did. And so, you know, be nice, just be nice, people. So taxable estates is kind of a really complicated area, and it's always fun. I like doing some of this planning with some of my clients out from the area because they're engineers and they want to see, you know, how this works out. And so we've got whiteboards and we're drawing things, and this is here and this goes here and this gets taxed here and this gets taxed here, and it's kind of fun. And my paralegals always learn a lot. So, but not everybody has that. It's nice that the exemptions are as high as they are. When I first started practicing law 25 years ago, the federal and the state exemption were the same, and it was $159,000. You know, I mean, okay, that was in the 90s, but still a lot of people had more than that, and you had to do this complicated estate tax planning for $300,000. So it was nice as it went up. And so here's how the tax reform has gone. So even when in 2000, I think, when they first started increasing the estate tax exemptions and they started bouncing up, what they did was they wanted to get them passed through Congress quickly. And so to do that, that law can only be effective for 10 years. So they started, you know, they increased the federal exemption up to $1 million, which helped a lot of people and reduced the number of state tax returns you had to do. And it was bouncing up and bouncing up and bouncing up, but then it had to go away after 2010. And so as estate planners, we kept thinking, so in 2010, there was no estate tax, but then in 2011, it was going to drop back down to 1 million after it had been up at like 5. That seemed ridiculous. We thought, well, Congress will get around to fixing that. That'll be fine. They got 10 years. Yeah, did not happen. It's like, okay, now we know 10 years isn't long enough. Okay, good to know. So then when 2010 came around, right, there was no estate tax, but the trade-off for no estate tax is you don't get a step up in basis. So what that means is if you have assets that you own when you die, and a house isn't a good example because you don't pay income tax on house appreciation anymore anyway, generally. But if, say, you have a business that you invested $500,000 in, or that you paid $500,000 to buy this business, and when you die, that business is worth $1 million. Your basis, the amount that business is worth, bounces up from that $500,000 to $1 million. So that if your kids turned around and sold that business right away, there would be no income tax paid on that appreciation that occurred while you were alive. So all of a sudden, with no estate tax, you didn't get that step up in basis is what it's called when you pass away. So if your kids turned around and sold that business right away, they would have to pay income tax on that $500,000. So that's a huge loss. I have, like wineries out on Red Mountain, clients I've worked with maybe in the past, and, dad, set up this business, a long time ago. He's invested it. He's fully depreciated this asset, right? There is no basis left in this. So if, he died and the kids sold the business, they were going to have to pay income tax on all of that money, which is just ungodly. And so the trade-off on not having estate taxes wasn't worth it, right? Because the income tax is huge. The estate tax at the federal level is a lot higher. It starts at like 45%, but the limit's much higher, right? So there's a lot of complicated planning that goes into that step up in basis thing. And then in 2010, what they finally did was they gave you the option. You could choose to not pay estate tax, or you could choose to pay estate tax under the new system that was coming in, and they increased the limits. So, there was a couple of years there where we didn't know what we were going to do with our 2010 estates because we didn't know how much estate tax they might have to pay, or they didn't. My favorite 2010 death story is George Steinbrenner died that year, right? The owner of the New York Yankees. They didn't pay any estate tax. That family can never sell that team. I don't know if that's a problem or not, but there's a huge income tax liability associated with that. So we do a lot of tax planning, and if you have a larger estate, this is a conversation I have. When new clients come in, we have them fill out an information sheet that tells us about their family and lists all their assets, and we like to have that in advance so we know kind of what topics we're going to be discussing with you and what kind of planning we need to do that's most appropriate for you and your family. Every family has different stuff, right, and different issues, and every family has problems. We all do. And it's really important when clients come to me that they tell me about those things. It can be very, very difficult for you, as a parent to deal with a child who has addiction issues or a criminal past, but I can't help you plan for it if you don't tell me about it. And there are lots of techniques to plan for things that people may not know about. One of the really common ones is disability. And this is kind of a family story. So my husband's mother had multiple sclerosis, and she was completely disabled by this. And so she was on Medicaid. When his grandma went and wrote her will, she thought, well, she's on Medicaid. She can't have assets. So I'm going to leave everything to the two sisters and not leave anything to her, which is super hurtful for that disabled person to be completely cut out. But, grandma thought, oh yeah, the other sisters will take care of her. They'll share it with her. That was my intent. But life happens and things happen, and sisters had other things going on, and there are always between kids there are like weird control issues that maybe as a parent you don't even know about. And so I always discourage people from leaving money to the other kids to take care of the disabled one. We can set up what is called a special needs trust. So that child's share is set aside for them. It won't count against them because they don't have control of the assets. There is a trustee who is responsible for managing that. There are instructions in the terms of that trust about how they can spend that trust so they don't disqualify for people from the federal aid that they are getting. It's interesting because sometimes there isn't enough money going to that person under the estate to care for them, and if it would disqualify them, that would do more harm than good. Sometimes there's plenty of money to care for them, but the benefits of being on that program to the child, you still don't want to disqualify them from receiving those access to services that they don't have if they're not on Social Security. Am I taking up too much time? Sorry. Okay, so special needs trusts, can help deal with disability. We can also do spendthrift trusts. If you have a child that either has addiction issues and you give them $5,000, they're going to be dead in a week or a month, right? We can set up trusts that put boundaries around what the trustee can spend money for their benefit or how much they can give them. I've had parents set it up or even grandparents, they can only get money that matches what they earn, or we'll pay for a place for them to live, or we will pay for education or treatment. So there are trusts that can help deal with some of those complicated issues. Family businesses come up. Family businesses are kind of funny. I had a group that I was working with. I'd worked for this family for 2 generations, but they always thought their problems were their problems alone, and no one else ever had those issues. And who's going to step up into the business, and are they going to run the business like I am? And if I sell my business to my child, am I really ready to give up control? Every family business has those same questions and those same issues. And they went to a conference one time and they were like, oh, there are families like this everywhere. We always thought we were the only ones. Families have people, and people are not perfect, right? Okay. The other common thing is step families. When you get married later in life and you bring all your children together, how do you plan for that? The Q-tip trust, that's an IRS term. It's for Qualified Terminable Interest Property Trust. And what that means is it's kind of like the marital trust. You can set up a trust that your surviving spouse has access to. Again, they get all the income every year. They have access to a certain amount of the principal. But then when the surviving spouse passes away, it comes back to my children. And you can leave that to someone else. Some people will give it to their spouse and then have it go back to other family members, or they will have it take care of mom until she dies, and then it goes to, but you're controlling where it goes after the beneficiary dies. That is very useful a lot of times. And a lot of times, and what I've done myself, so I'm second marriage, my own kids, is I've got life insurance that pays out to my children when I pass away, so that they're not sitting around waiting for my husband to die so they can get some assets, right? So that's, and you can also use I've seen people use life insurance really well for funding special needs trusts. Maybe you don't have a lot of money to take care of that disabled child. I have a nephew who has a disabled son who will never be able to live on his own, but you can have life insurance that when you pass away, it funds that special needs trust. So now there is money to take care of that child in the place of you being gone, because you've been the caregiver. It's important, I think, to have a plan, talk about, think about what the options are and what's going to happen to avoid conflict. Like I said, I think estate planning is a gift for your family because it gives them a plan. I think it's good to communicate about these things so that people know what's coming and no one is surprised. The hardest conversations I have are with families after mom has passed away. And even if she did have a plan, and one son is saying, well, she told me that I would get this, or she told me she would pay for my kids to go to college, or she would tell, and if they didn't put that in the documents, that's not going to happen, So I'd like to encourage people to communicate, but there are clients who don't want nobody to know their business. Is Anna Marie saying something? Her little light's flashing.
Anna Marie, did you have a question?
Oh, no, I'm sorry. I accidentally hit unmute.
That's okay.
Oh, okay. No, I think you were on mute. I saw your light flashing. It's okay. Another option to avoid conflict is professional administration of your estate. A lot of times, if your kids don't get along, don't trust each other, or they're busy or they're spread out all over the world, naming a professional trust company to handle it is a great option because there's professional administration. They've got experience with handling all sorts of things. It takes the burden off your children and cuts down on conflict amongst them. I had an estate one time where the family had 11 children. And that was after, I think, a couple of children had maybe not survived. And then there were a couple of sets of twins. But when you have 11 kids, you have like generations of kids, right? And so they didn't all agree. And there were just too many people. So I was thankful that they had appointed a professional administrator. And the kids were thankful because the oldest son didn't have to keep taking care of things. He's like, my life just got a lot easier. Yes, it did. We will get all of mom's junk mail. We will deal with all the weird little creditors. We will, deal with all the out-of-state assets. So sometimes, having a professional administrator is a huge benefit to the family afterwards. So particularly after both parents have passed away, because it allows the siblings to just be siblings. and it avoids the control issues. But the flip side of that is, you know, beneficiaries never like the fact that there's an outsider in the family business. So it's all kind of a balancing act, and it depends on your family. So I always ask, particularly parents, when I'm doing planning, tell me about your kids. You know your kids. Do they get along? Can they work together? And do you know if they can get along? But one of the most frustrating things to me is to sit in a conference room with adult children who are maybe in their 50s and 60s and have them still whine about things that happened when they were 8. You know, like, you're a grown up and that has nothing to do with it. So let's move along. That is it. That's a lot of information.
Are there any questions?
I don't have any questions, but I wanted to thank you.
No,
That was very informative.
Oh, thank you. And if you think of something later, you know, Erin has my contact information, or you can, you know, Google me and I come up. I'm at Gravis in Richland. I'm not going anywhere. So it was nice of you to show up. I wish there'd been more, and, you know, but thank you for coming on a Friday morning.
I don't
It's
know
before
what
Christmas.
happened. We had, like I said, we had about 9 people signed up, but you know, sometimes during this time of the year, things happen. But again, I have this recording. We will share it out with people as well as your contact information. I can say selfishly, I was the one that kind of wanted this conversation because I have talked to Catherine before. As a single mom, I have always felt compelled that I want to have some things in place. So if something happened to me, I knew for sure that my daughter was going to have financial resources that I put aside for her, safeguarded and put for her future use. So Stella, thank you very much, because this was something that I have long been putting on the back burner, and has made me realize I really need to take care of this, plus looking at my own family too. And I'm the supposed executor of my parents' estate, and I really don't know much of anything. So I'm always hoping that, you know, I won't be the big surprise when my parents do pass as to what exactly I'm supposed to be overseeing or assisting with or anything like that. So I think it was a lot of information, but certainly very valuable. Stella, thank you so much. I appreciate it. And thank you for your time today too, because I know you have a full plate.
I love doing this. And if you do call in and want to follow up, let them know that you were part of this presentation. And so I will make sure that you get like a free consultation and a discount over your final package.
Right on. Thank you. Thank you. Well, with that said, everybody, happy holidays. And we'll see For You Fridays resume again in 2020. We have 401k planning coming up. So see, Stella, we have all different things. But thank you all for being here today. And thank you, Margot and Anna Maria, for being here today. And you guys have a wonderful weekend.
All right.
Bye.
Thank
Merry
you. You
Christmas.
too.
Have a great weekend.
Merry Christmas. Bye-bye.
Thank you for having me.